there is no more dilemma as to whether trials are necessary. The only remaining dilemma, in view of the fact that 2 fugitives are still on the run, is whether the tribunal has really completed its job. But we can talk about the legacy of the tribunal and what still remains to be done through no fault of the tribunal, and whether perhaps there are some unsatisfied expectations.
Yeah, let's come to you, Minister, State Minister Pulac, in terms of your comments, and then we will move to the other side of the panel. Please.
Naime, htjela bih samo na sve ovo dodati da...
I just want to add to this that something that concerns political authorities, because ministers are, of course, public figures. The necessity for regional cooperation in prosecuting war crimes and bilateral cooperation, of course. At this morning's panel, we emphasized the very good cooperation between Serbia and Croatia. I believe we have exchanged material on about 28 cases so far. Also, the agreement on international legal assistance has been ratified between Croatia and Serbia. Mr. Tolek and Mrs. Maljovic have managed to create this umbrella document in less than 6 months, and that creates new room for some new agreements. We have made it clear that we want to deal with all the war crimes, and as my colleague from Bosnia and Herzegovina said, the countries in the region have already established this cooperation, and they are doing their best to do this work. Concerning political authorities and what is in their jurisdiction, Serbia has removed one formal obstacle that existed before, namely that its citizens could not be extradited. This is a clear demonstration of Serbia's readiness and willingness to do all in its power, and it is making specific steps to that end.
Appreciate that last intervention and want us to move on. I take away from this the interesting and important demonstrations of leadership by political actors, the Srebrenica Declaration that was referred to, and the interesting point about how leadership's role changes as public opinion in the country changes as well. I think that dialectic is very, very important for us to keep in mind. But let's turn to the tribunal right now. And I want to start with President Robinson, and a question for you, sir. Really looking back on the experience, and I know the weight that you personally and professionally give to vesting and helping vest national jurisdictions with ownership over these trials in their respective countries. Looking back over the practice of the ICTY, what do you think the tribunal could have done differently or better in a way that would have more facilitated that sense of ownership? We've heard a number of different examples over the last 2 days, but I think it would be great to get your reflections in terms of what, in retrospect, could have been done a little differently with greater emphasis in national ownership. Please, President Robinson.
Well, let us begin by looking at the rationale for national ownership. The cases that we try at the tribunal are cases that would normally be tried elsewhere. They would normally be tried in domestic courts because generally criminal jurisdiction is territorial. It is exceptional circumstances that have given us the jurisdiction which we have. And with that in mind, we should have at all times be very keen to transfer ownership of those cases to the national jurisdictions at the very earliest moment. It was in 2005 that the Bosnian State Court was established, and looking back at it now, I wonder whether that might not have been done earlier, and to give those constituents a greater sense of ownership. Because as I said, by national ownership, I don't simply mean transferring cases and giving help. I mean the recognition that it is up to the national courts, to the people of the region, to take charge of their destiny in relation to their cases. Another big regret that I have is, and I apologize for that yesterday, is in relation to the question of language. Yeah. It's really very regrettable and unfortunate that transcripts of our proceedings were not in the national languages of the countries concerned. And as I said, we are now seeking to set that right. But I believe that's another area in which the sense of national ownership would have been strengthened. Of course, there are many other things, but I think generally, I think engineering and facilitating closer cooperation with the countries in all respects, and those are just two examples.
Okay. Thank you for that. I want to turn to another example, or a particularly interesting example, and it's a question for the prosecutor. And that is the work of the dedicated transition teams in the Office of the Prosecutor that have been established, not simply to transfer files and material, etc., be it 11 bis cases or Category 2 cases, but as I understand it, to provide comprehensive assistance and follow-up with national prosecutors. And what I'm interested in, Mr. Prosecutor, is understanding what were some of the real challenges for your staff in making that happen in the best and most effective way.
Thank you. In fact, the transition team was set up, was created after the completion strategy was decided. Right. It was, in fact, in 2005 when the Tribunal started considering transferring some cases where indictment has already been issued to the region, to the national prosecution offices, and where there was still a lot of investigative material which was available with the Office of the Prosecutor, but where no indictments could anymore be issued, and those information were mainly in relation to lower-level perpetrators. So it was for this purpose that the transition team was initially created, to put all this information together, to collect this information, and to transfer this information to the national prosecution offices. And this process was finalized in December. In fact, we have transferred investigative material in relation to 41 potential suspects, mainly to Bosnia-Herzegovina, where colleagues have to continue and to finalize investigations, so those are not trial-ready cases. And it was really in the context of the preparation and the transfer of these cases that a much more intensive exchange took place, because while transferring this material, we received automatically a number of questions in relation to this material, requests to access our databases in order to complete local cases. And then the next phase was really that we were receiving many requests in relation to their own investigations in the national prosecution services. So where initially it was mainly to help ourselves by getting material together to be transferred, it is today really an institution, I would say, which is used by us collegiately by the three chief prosecutors in the region, from the national authorities, and from our office. The next step, I would say, was the creation of the liaison prosecutors, right, having the national component integrated in our office. And I fully agree with what the colleagues have said this morning, that it is very important that this task as such and this component will in one way or another be maintained during the remaining lifetime of the tribunal, but also afterwards in the residual mechanism, because we all know today that our colleagues with the national authorities will have to conduct investigations for many years to come after the close of the tribunal.
Follow-up for you. What effect is the implementation of the completion strategy going to have on those transition teams? And I want to put my cards on the table here in the sense of concern that while the tribunal certainly does need to close down and is in the process of closing down, the completion strategy as originated with the Security Council in New York cannot become a basis for cutting corners or taking shortcuts, particularly where due process of accused are concerned. But in regard to the assistance of national courts, what effect is the completion strategy going to have on the staffing that seems to me very important in terms of these national jurisdictions?
Yeah, the completion strategy is a reality. I think that we all agree at the tribunal that there can be no compromise on fair process, on interest of justice being not respected. So I'm not too much afraid in terms of proceedings where all rights will be respected. In terms of completion strategy impact on the transition team, we will indeed, as far as the OTP is concerned, be obliged to downsize the next 2 years by 60% our human resources. But of course, the transition team component will be there. And we have asked the European Union to continue financing the project of the liaison prosecutors. So I hope they will positively assess our request, because we absolutely want to have the liaison prosecutors for the years to come still integrated in our office.
Okay. Glad to hear that. Please, President Robinson.
As the completion strategy has been mentioned, I thought I would say that, in my view, the unfortunate thing about the completion strategy is one of perception rather than fact. Okay. As a matter of fact, it doesn't affect the work, the judicial work. We have had motions filed contending that has affected some decisions. That's a matter of fact. But the very unfortunate thing is the perception, which quite often, as you know, can be more injurious than the actual factual situation. And I regret very much that we had to have a completion strategy, which, by the way, was originated by the tribunal itself.
Understood.
But it doesn't really make any difference as far as I'm concerned where it originated. It exists. Right. And the perception is out there that somehow it has affected the fairness of the proceedings. It is not a fact, but the perception is still there. And that is a matter for very great regret, as far as I'm concerned.
And if I may, I don't mean to feed that perception by my question, but your response does raise, in my mind, the question, and what role, if any, is there for the tribunal in addressing that perception about negative effects?
The role of the tribunal in that respect is very, very clear. It must ensure that no measure is adopted at the expense